this recording, I'm going to go over the statutory or legislative modifications to contract law. Now, in the earlier recordings, we would have heard and gone through a large number of rules that establish and really construct contract law in Australia and Queensland in particular. But there are some really important modifications that Parliament has done, both recently and also in the case of the sale of goods legislation quite some time ago. So there's really two statutes we're looking at: the Sale of Goods Act and the Competition and Consumer Act. The latter, Schedule 2 of the CCA, is known as the Australian Consumer Law. So we're going to talk briefly about the history of these. Then I'm going to go through specific provisions in both of these pieces of legislation. When looking at the history of contract law in the broader sense, because this is private arrangements, for a long time there really wasn't much that a person would have in terms of recourse. This idea that the market is hands-off, laissez-faire, meaning let do in French, which basically was the idea that transactions between individuals should be completely independent and separate from anything to do with government. And really that, for a long time, was the way that contract law was viewed, not just in the British common law system, but globally. In many legal systems, particularly the early ones, if a person actually went and lied or did something deceptive or deceitful in terms of contracting, then that would, I guess in the broad sense, have been dealt with under the equivalent of what we would call a criminal law now. It's really everybody is angry about one person for lying or cheating. But in terms of what we would look at as private deal making, that really is only a relatively recent component phenomenon. But that doesn't necessarily work, particularly in situations where you're having a lot of transactions and there are a lot of people, and particularly when dealing with parties that the merchants or individuals are parties that they don't know particularly well. It's one thing to have merchants that deal with each other continuously, to be able to really manage their own rules and laws between themselves. Eventually, though, the law and legal system, and certainly from our perspective, the British system, came to recognise that there really has to be some sets of rules governing individual private deal making. And this idea of the caveat emptor principle is that, look, the default rule is let the buyer beware. And this really flows from the idea of merchant law. When merchants are dealing with each other, they know the market that they're dealing with. They know what to look for particular goods. They know to go through and carefully check. And so that's something that the courts of in the British common law system really reflected as part of contract law going back hundreds of years. Now, the merchant law, though, and again, this really comes back to the idea of the common law itself being flexible, because the merchant law started to be incorporated into the common law itself. And so you ended up with a series of rules that were decided by judges that often, when they had referred back to what merchants had historically done. By the end of the 1800s, in Britain, it was decided that these rules, some of which were actually pretty straightforward and commonsensical, were nonetheless not particularly known by individuals and persons, particularly this new industrial class and the new wealth, or the new rich, nouvelle rich in Britain. And so the UK Parliament passed the Sale of Goods Act, and that essentially codified it, a whole range of rules that had been in the common law to do with the sale of goods. And so that essentially acts as something of some minor form of consumer protection, but really it was just to codify things, for people to be able to see what the particular rules were. So the Sale of Goods Act itself is not actually very long, and it's quite straightforward and easy to read, particularly for its time. However, throughout the 20th century, there was this recognition that that really wasn't going to be enough, and that by and large, the sale of goods to people, to ordinary people, consumers, was still heavily geared in favour of the supplier. Now, in the sort of post the Second World War, you also had the rise of large corporate entities that had the benefit of specialization to be ruthlessly efficient at going and producing goods. And so that, for example, supermarket chains started to pop up. And again, there was a recognition in the developed world that the existing sort of laissez-faire and caveat emptor type rules really wasn't enough. And so the Trade Practices Act was established in the early 70s, and that was designed to include some form of consumer protection. And in 2010, there was essentially the Trade Practices Act was taken and included, incorporated, and broadened in scope as well. And Schedule 2 of that of the CCA is a clearly written out and quite legible and readable document called the Australian Consumer Law. And we also found in the latter half of the 20th century, the various parliaments have been very keen to try and stop people from actually going to court to resolve their disputes, particularly for minor disputes. And so they've developed systems of means, both alternate dispute resolution mechanisms, but also the systems in place for various industries, such as the Ombudsman. And these are designed to really give consumers who have, in terms of relative bargaining power, much, much, much less than people, the equivalent people would have been a few hundred years ago. So when looking at these two pieces of legislation, we're going to start with the Sale of Goods Act. And the key thing to know about the Sale of Goods Act is that it's to do with goods. Now, the really important thing there is that it is to do with goods and not at all to do with services. A Sale of Goods Act has a very basic statutory definition in Section 4, subsection 1, which is it has to be a sale of goods. It has to be for money. If there is a barter arrangement or an auction sale, that is not a sale of goods. So just make note throughout this recording, where I refer to price, that is the money about that is exchanged for goods in a sale of goods contract. One of the really important things that the Sale of Goods Act tried to really be able to describe and make clear to people is the idea of passing of title. A legal title, which is the same as the legal ownership of goods, is a really important concept when we're dealing with contracts for the sale of goods. It's a really crucial moment, and so and again, most of the disputes that arise in terms of sale of goods cases really revolve around this idea of title passing. Because it is that idea that at law, once title is passed, the goods belong to the other party. Now, sure, you may be able to go through the courts and you may be able to get things reversed, or you may be able to rescind. There are all sorts of mechanisms that are there. But the default position is that once title has passed, the other side has to do something in order to change that, to reverse that in some way. Now, there's some other sort of really important things that arise from this passing of title or passing of legal ownership. The first one is risk. Once something is yours, if that thing is destroyed or damaged or lost, it's going to be your responsibility from that point. So certainly for contracts of large contracts of goods, the point in time where things become insured is very important, and so knowing and being very certain about the point in time when title passes in terms of that is going to be absolutely critical. Similarly, the right to actually demand money for the contract. If you're the seller, once title has passed in those goods, you have this right to demand payment. And that can be very important too, particularly when, as can happen when these things come in disputes, when the parties or the buyer usually tries to get out of a particular contract and to try and avoid having to pay for goods. Once the title's actually passed, the seller has this right to demand payment. Also, in the common law, once title is passed, you get rights. You're the owner. So as a result, if somebody comes along and damages your property, you get the right to sue them in conversion. If they take it, move it, do something to it, repugnant to your rights as the true owner, you get the right to seek some form of compensation through the court system. Another important aspect of title, legal title, means that once you own something, and it sounds a little commonsensical when I say it, and a lot of these rules can be like this, but once you own it, you have the right to unsell it. You can pass good title to a third party, and you can only do that if you have title to those goods yourself. Now, also in situations where a company is about to be liquidated or a person's about to go into bankruptcy, it's important to ascertain when title is passed to goods to people that have, either entities that either become insolvent or become bankrupt. Because particularly from the seller's perspective, when selling to a bankrupt, if title hasn't passed, then even if the buyer, the now newly bankrupt buyer, is in possession of those things, if title hasn't passed, you can walk in, grab your goods, and walk out. You are still the legal owner to those, and that can be really important when disputes arise. When parties, sellers, on-sell goods to companies that are about to be liquidated or individuals about to go bankrupt, because you will rank ahead of creditors, other creditors, when trying to recover things, because you can recover the goods because you're still the legal owner. And finally, and this is a really important rule, and maybe not that commonsensical and not that straightforward, but it's very important to know. In Section 14, subsection 3 of the Queensland Sale of Goods Act, it goes like this. Once the buyer has accepted the goods and title has passed, very importantly, a breach of a contractual condition from that point forward is actually treated as a breach of warranty. What does that mean? It means you can't terminate the contract because there's some form of substantial failing, a breach of this very essential term. Terminate that contract at that point and discharge future obligations. You can only sue to recover damages. In other words, if you've bought something and it is terribly faulty under the default sale of goods rules, you can't send it back. You must keep those goods. They are now yours once title is passed. You can only sue to get some sort of money compensation from the seller. It's a really important rule. And just note that with these rules, and in fact almost all of the rules in the Sale of Goods Act, they can actually be overwritten by agreement between the parties. So if the parties agree for a time where legal title passed, or they agree that title can be revested to the seller, or they agree that the seller retains title until the goods are paid for in full, then these are clauses that can be included into a contract. And very importantly, under the Sale of Goods Act, the agreement between the parties will trump the default rules that are established in the Sale of Goods legislation. However, as is often the case, the parties don't agree on a certain time to transfer title, or they don't necessarily agree to override things in the Sale of Goods Act. But by and large, the Sale of Goods rules were just the defaults. They are the norms. They are the standard rules for contracting for the sale of goods. And so the rule for the time and for the transfer of title is going to, by default, be what the parties agree to. If they agree that title only passes when the goods are fully paid for, then that's fine. If, however, they haven't agreed, then one of 5 rules that are established in the Sale of Goods Act will apply to that particular sale. And the default rule is, if there are goods and they are sold, and then there's no other agreement in terms of when titles are, if those goods are ascertained, in other words, they exist, and they're specific, in other words, they're specified, that both parties know and can see and can specifically identify what the goods are, and they're ready to go. They don't require any additional work. They're in what they call a deliverable state. Then title will actually pass when the contract is formed. That is the default rule. And the actual delivery time or the time of payment are not relevant in terms of the sale of goods if this default rule 1 applies. Rule 2, in terms of transfer of title, is really just an exception to rule 1, and that basically arises when the seller has to do something. They have to paint the goods, or they have to furnish them or customize them in some way. In that situation, then they need to put those goods into what we call a deliverable state. And so title won't pass until that particular action has been taken and the buyer has had notice that that particular series of steps has been done. Rule 3 is similar, and it's an exception to Rule 1, in that it can arise where the seller has to weigh or measure or do something else in order to ascertain what the final price is going to be. And so title won't pass until the seller has actually done those particular set of measurements, and again, given the buyer notice as to what that amount is, basically tell them what the price is going to be. Rule 4, in terms of the passing of title under Section 21, is where the goods are actually delivered to the buyer, but the buyer has to do something, usually to just approve and say yes, or tick a box or sign or something. In that situation, then the title won't pass until the buyer actually goes and approves of the goods, or does this step that the parties, in order to tell the seller in that situation that they have actually accepted the goods. Now, can the buyer just wait forever? No. The title will pass after a reasonable length of time expires. So if the goods are delivered to the buyer and the parties agree that the buyer must approve them in some way, give some form of notice, that it can either be when the buyer gives notice or after a reasonable length of time expires. Finally, Rule 5 applies where the goods don't exist yet. And that can be a situation where the goods need to be created or manufactured in some way, or the goods are something usually that the seller is in the business of selling, where they have to go into their warehouse or go into their silo or go into their place where they have the goods stored in bulk and take some and put them in a deliverable state. Now, this idea of the goods don't exist in relation to the contract until this happens. And so the phrase they use is that the goods must be unconditionally appropriated to the contract. If you're the seller and you have a silo with 1,000 tons of wheat, somebody comes and buys 1 ton, it is not until that ton is taken out and usually put onto the truck and reaches the point where it can't easily be taken back, usually the point when it starts to go into transit. And that is the point in time where title will pass to those particular goods by default. Now, importantly, when a party has legal title to goods, they then have the power to on-sell that to third parties. And this, to us, often has a very sort of intuitive feeling to it. That seems like a pretty straightforward rule. And while a lot of things can seem to be very straightforward, at law we often have to come out and map out rules to things. And sometimes those rules, when we sort of sit back and analyze it, aren't actually as straightforward as it might originally seem. So this default position is, though, when a person does sell goods, the person acquiring them, buying them, can't acquire better title than the original seller had to those particular goods. This is known as the Nemo Dat rule, and it really, just simply stated, is the idea that you can't sell something that you don't own. And so as a result, the person buying it can't actually become the legal owner if the seller didn't have good title to start with. The first of these exceptions is estoppel. And that's a situation where one party, despite there not actually being a contract, has nonetheless made some sort of a promise which is going to lead to an injustice for the other side at a subsequent state. And the case example we used here is Eastern Distributors and Goldring. And in that situation, a person had a business, a guy called Murphy. He had a Bedford truck, but he wanted to buy a Chrysler sports car. And so he went to the dealer, and the dealer said, well, look, if we do the finance just for this car, you're not going to get it. So how about we apply for finance for a truck and a car and see if we can get both of those things? And the difficulty there was that, well, he already owned the truck. So nonetheless, he gave all of the forms, filled it all in, left that part of the form blank. And the dealer then applied for the finance, but it was actually rejected for the car. So finance was only granted for the truck itself. And so the difficulty then arose that later on, Murphy went to sell the business to this third-party Goldring. And at some stage later, the finance company called up and said, well, that's our truck. We had a hire purchase arrangement, some finance across it. We would like to have our truck back. And of course Goldring said, well, no, I've bought this in good faith from the person who was the legal owner. But in that situation, the courts actually sided with Eastern Distributors, and they said, well, in this situation where Murphy had done or taken this step of giving the forms, leaving the information blank on it, giving the advice, he had armed the other side with enough information to think that there was a fully formed and valid contract, and as such, he was stopped from relying on that strict situation, the strict rights, and this did work as an exception to the Nemo Dat rule. Another exception to Nemo Dat is agency. If you appoint somebody to go and be your agent, to bind you in contract, it's a little nonsensical to turn around and say, oh, well, no, they weren't the legal owner, I was. And so in that situation, if agency is fully formed and valid, then that will be an exception to the Nemo Dat rule. Similarly, a mercantile agent, where a person who is armed with the powers of making contracts and selling particular classes of goods, then if you leave your goods, for example, you leave your car with a car dealer, and through some error or accident, then the car dealer on-sells the car. In that situation, that'll act as an exception to Nemo Dat. The buyer will actually acquire good title. The next two, 4 and 5, the sale under a court order or a common law rule or a statutory rule, are pretty straightforward. The courts have the power to override the Nemo Dat rule, and Parliament certainly does. Similarly, in situations where, I guess in the olden days, where there's a mistake as to the identity of the parties, or I think more commonly where there's been some form of innocent misrepresentation, and the innocent side in these types of contracts does get this right to undo the contract, to either void it under common law or to rescind it in equity for misrepresentation. In either of those situations, if that hasn't been done before title passes to a third party, that's going to act as an exception to Nemo Dat. That person loses that right. And exceptions can also arise by either the seller in possession or buyer possession, and that's in situations, and again, this is mapped out in the Sale of Goods Act, where goods have been bought and sold to the other party, and then usually through no fault or knowledge of that particular contract, the goods that have been either left with the buyer and have then been on-sold, or have been left with the seller. So the next two exceptions apply where the buyer has left the goods with the seller, and so in theory title is passed, but they've left them with the seller, and then the seller has usually inadvertently on-sold them in good faith, and so another person in good faith has gained title to those goods. In that situation, that'll act as an exception, and that buyer will get good title to those goods. And similarly, when the seller has delivered all of the title deeds and with their full blessing, pass the goods on to the buying party, and then they, again in good faith, believing that they have full unencumbered title, on-sell them. In that situation, even if the title was somehow defective, then that will be an exception. And again, the buyer purchasing in good faith without knowledge of any previous defect will obtain title to the goods. And the final exception to nehua doubt only applies in some states and jurisdictions, and not Queensland, and that is sale and market overt. This is an old rule that suggests that in situations where there is a marketplace and everybody can see what everyone else is selling, and your goods are sold in that marketplace, then in theory you always had the capability of going, seeing your goods and asking for their demand. Doesn't apply in Queensland, but it may come up for those that operate in those other jurisdictions. The next area to look at is the implied terms in the Sale of Goods Act. Now, again, all of these rules can be trumped or overcome by express agreement between the parties. But assuming that they haven't done so, though, Sale of Goods contract will have these implied terms. And I'm just going to run through them one by one. The first of these is that when you buy goods, there is an implied condition that the person selling to you actually had good title to those goods. That title is free of defect, and they are actually capable of passing good title to you. If they don't do that, then you have this right to terminate the contract and to seek damages. There's also, in situations where the contract for a sale of goods is done through either by description or by sample. So either goods are described to the buyer in a particular, usually carefully mapped out way, or a sample is produced for those goods, for the goods that are being sold. And there's an implied term, and again, a lot of these rules are common sense. There's an implied term here that they're going to match. So the bulk of what you're going to get is going to align with the sample, or the goods actually comply with the description that is given as part of it. But make note that where there is a description, again, this description will form part of the term. This is going to be different and distinct from there being some form of misrepresentation. In this situation, the implied condition gives the other party the right to terminate the contract and seek damages. Now, in section 17, subsection A, there is an implied condition that the goods are fit for purposes disclosed to the buyer. So if disclosed to the seller, if the buyer actually states that the particular purpose of the goods that they're buying is to do something, then the goods have to actually be able to do that. So an example here, if I say that I'm buying all of this, say, expired food, and I'm going to use it to feed pigs, and I've told the seller that I'm going to use it to feed pigs, and this food soon turns out to be unsuitable for feeding of pigs, then that's going to be a breach of that implied term. However, this is different from section 17C. If, for example, I just went to buy low-quality food, expired food that would unsuitable for humans, but I don't state that I'm going to feed it to pigs, or I do state that I'm feeding it to pigs, but instead I feed it to some other animals. So my prized minks, for example, and it turns out to be suitable for pigs, but unsuitable for the others. The courts will then look at the underlying nature of this contract to determine whether or not as I guess a lesser standard, the goods are of merchantable quality. What does that mean? It means that in relation to the types of goods that that particular seller deals with or normally sells, the goods must be of a minimal standard to really be classified to be within that particular category. So going back to the example of selling low quality food for animals, in that situation, and again the case example here is Ashton Piggeries, if food is sold, it still has to be merchantable quality. It can't kill animals. And in that situation, despite the fact there was piggeries that were purchasing it and feeding it to minks, there the court said, look, there's this minimum standard that the food's not going to kill animals that it is that it's supplied for. And in that situation, that will be a breach of the English equivalent of our 17 subsection C. There's also an implied condition that, again, and this is similar to the sale by a sample, where there is a sale by sample, the bulk of the goods have to comply. They have to actually be the same as the sample in terms of quality. Also, there is an implied condition that where there is a sale by sample, that the goods that are actually supplied have to be able to not just comply with the goods, they have to actually be free from some form of defects that aren't going to be visible unless you would actually be able to examine the sample itself. In other words, you can't argue later on, oh hey, there were defects in the bulk, if those defects couldn't reasonably have been seen by reference to the sample itself. So this is the end of my discussion on the Sale of Goods Act, and again, just make note, it's quite a readable act, it's not very long, but the important thing to note is that the rules in the Sale of Goods Act, almost all of them, can be overridden by agreement between the parties. That's a really key distinction between the sale of goods legislation as opposed to the Australian Consumer Law and the CCA. Now, the Competition and Consumer Act, or CCA, is fundamentally designed both to protect consumers against small parties, those not easily able to take up arms legally against larger players. But also it governs the antitrust laws to prevent anti-competitive and monopolistic behaviour in the marketplaces. And essentially this is being developed from the Trade Practices Act from the early to mid-70s. However, the TPA only applied to companies. You know, this quirky situation where you had to use local state law, where the person supplying goods was either a natural person or running under an ABN or running a partnership, as opposed to them being or running their business as a corporation. In that situation, the former would be under the State Fair Trading Acts, whereas the latter was under the Trade Practices Act. In 2010, all the various states and territories came together, and the states relinquished their power in this area. They gave the Commonwealth the power to create this piece of legislation, so it's uniform across all states and territories. And each of those jurisdictions passed a law saying this is a law of this particular state. And so that essentially supplants the fair trading laws and rules and regulations that used to exist in the state of Queensland. I also note that the Schedule 2 of the CCA actually is the Australian Consumer Law. So if you do need to go and find the ACL, it is Schedule 2 of the Competition and Consumer Act 2010 Commonwealth. While there are a host of protections for consumers and businesses in the Australian Consumer Law, we're going to look with one of the more important ones, which is Section 18 of the ACL. And that prohibits misleading and deceptive conduct. It's really important to note in this definition that while misleading and deceptive conduct has this broad definition that we'll get to in a second, it only applies to persons in trade and commerce. Now, the definition of person under this part of the Australian Consumer Law does include companies and partnerships as well. But this key component is that it is only to do with those who are in trade and commerce, so that it will not apply to private sellers of goods. Now, when determining what constitutes misleading and deceptive conduct, the courts have spent a lot of time trying to map this out, and generally they've explained it in slightly different ways each time. But in the broader sense, these are the core requirements for conduct to be misleading or deceptive. The first thing is that the particular conduct has to be examined in the context of the audience and the background facts that it is actually expressed or undertaken. The audience matters when determining whether something is misleading and deceptive. Secondly, the particular conduct doesn't actually have to lead someone into error. It just has to be capable of leading them into error. It's a lower bar than for example, common law misrepresentation. Thirdly, it has to be caused by the conduct of the defendant, so that the particular misleading behaviour doesn't have to be intended to mislead. And that's a really key distinction here. It's just that it has to be capable of misleading, and the fact that this particular conduct or these statements of representations came about has to have been caused by the actions of the defendant in this particular situation, even if they didn't necessarily intend for it to happen. It's actually that causing of the this capacity to be misled is actually, in theory, it's of strict liability. You don't have to actually intend for it to happen. And there has to be an actual a substantial chance that the conduct will actually mislead. So either it did mislead, or it has to actually have the capacity of doing that. And things that are far too remote or unlikely to mislead aren't going to constitute misleading and deceptive conduct under Section 18. And finally, make note that this test is one that must be done by the courts. Now, in earlier recordings, I've talked about sort of things that can be done through self-help. In this situation, only the court can determine whether a particular conduct is either has led or is capable of leading parties into error. And it's an objective test, and it is one that the courts can only determine itself. So it's whether or not a reasonable person in that situation would have either been led or whether the conduct would be capable of being led by that particular conduct. Now, when looking at the conduct of the parties, we're examining this context that the conduct is being examined by the court within. And we look at the class of persons that are likely to be impacted or affected by this particular misleading conduct, and we look at the class of persons and then assess. When thinking about this class of persons, what is the probable effect on that class of persons in terms of them being misled? And so the example here is that, if conduct may, for example, have been misled, might have misled children, for example, into thinking that certain things would happen, and may not have misled adults, the courts will then look at the context of, maybe this, these particular series of advertisements, for example, might have misled children, but they were run at 9:30 at night on television. So in that situation, that's not going to be probable that that particular class of persons is going to be misled. And also make note, and again this operates as some form of defense to this, that it's only the ordinary and reasonable members of that class. It's not the unusual or particularly gullible or susceptible members of that class who haven't failed to take reasonable care to protect their own interests in that situation. Also, the conduct must actually be capable of leading the audience into error. They must actually have this capacity to create or actually mislead, create a circumstance where one party is actually deceived in some way. It's not going to be sufficient if it's only going to confuse people or to leave them open or wondering about what the impact or effect of this particular statement is. That's not going to be sufficient. It has to actually have the capacity to lead them into error. And the defendant's conduct has to actually have caused this misleading or deceptive event to have happened. Again, it's not whether they intended to or not, it's whether they caused those things to be put in action. So, for example, if they paid for advertisements, they are setting in motion a chain of events, even if they never went back and checked or didn't intend for these, the ad company to do or state or say things that may have been misleading. They set about that chain of events by paying for the ad campaign to go into place. And again, it's a straightforward test, usually the but-for test. But like in contract law causation, we look also at there's a little bit of whether a bit of common sense flows into it as well, whether the results would have happened if the particular party didn't do something in that situation that led to the conduct that was capable of misleading parties into error. Now, there's another prohibition in the Australian consumer law that prevents parties from engaging in unconscionable conduct. And this is expressed in two different ways. The first, in Section 20, is again applies to parties in trade or commerce, but it's a prohibition on engaging in unconscionable conduct within the meaning of the unwritten law. What that means is the rules of common law and equity. So in an earlier recording, we looked at the doctrine of unconscionable dealings and Amadio's case, where this was mapped out by the High Court. And all the Australian consumer law does is say that, look, Parliament has said, we accept the courts have mapped out this particular concept of unconscionable conduct. And all we are saying is that, look, if a party in trade or commerce undertakes unconscionable conduct, and again, the plaintiff has to bring the particular action and prove this on balance of probabilities. If that's the case, as well as getting the common law remedy, which is just to rescind the contract on equity, and as well as that, they will get all of the wide range of remedies available to the court under the Australian consumer law. And so that's what happens then. The reason why this has been included in the ACL, a mechanism for allowing the court to not just rescind the contract, but to do a wide variety of other remedies as well. Grant injunctions, grant damages, which is something not usually awarded under equity in those situations, but also award some other things. For example, they can enforce some form of penalty mechanisms upon entities that do that. They can create orders that parties, for example, that breach Section 20, subsection 1 in this case, to undertake training, to actually enforce them to do things, and tell their staff to not do this in the future, and make them apologise, to actually make them take out public advertisements, saying, hey, sorry. Now, there's also a statutory set of rules to do with unconscionability, and they had to do with the supply of goods or services, a much broader category of things in trade and commerce, where the parties in this situation, one of the parties has engaged in unconscionable conduct, and here in Section 22 they actually map out what that means, and they have a wider variety of circumstances that a party can act unconscionably to another. Now, you may recall from the earlier recording, unconscionable conduct within the meaning of the common law and equity involves the misuse of a special disadvantage of the party. Under Section 21 of the ACL, though, that's not actually strictly a requirement. And so there can be situations where there are an inequality of bargaining power. In that situation, the courts can actually award or find some sort of remedy for the plaintiff in that situation, where again a stronger party has misused their power, and that's something that's not available in the common law. The Australian consumer law also prohibits a wide variety of other unfair business practices. For example, Section 32, offering prizes to a competition but not actually intending to actually provide those prizes or some form of incentive, particularly things like free products as well. Bait advertising is prohibited in Section 35. That's where a party usually places an ad for a small quantity of goods to be sold at a very, very cheap price to entice or encourage people to come in, whereas in reality they only had a very small or sometimes non-existent quantity of those particular goods. Section 36 applies where one party wrongly accepts payment, usually for goods that haven't been supplied or where money has been received by accident. If a party does that in trade and commerce, then they can suffer the wide variety of remedies, or the innocent party can apply for those remedies under the ACL. Similarly, where businesses supply goods to parties without in situations where they haven't actually been asked for. You can probably think about this in terms of personal things where people would have books and such like that they would deliver to your postal address, and then they would ask them back at some stage later on, and if you didn't return them because you've thrown them out, for example, then they would send you an invoice, and that type of business model is now prohibited. And pyramid schemes, the idea where there is usually these have the outside appearance of being legitimate businesses, where a person sells a particular product, and that's fine, but most of their actual revenue comes not from selling the product, but from selling usually the right to sell those products. And in those situations, which can also be referral selling as well, again, the definition can be a little murky between these two, but these types of schemes, which invariably come unstuck, where one person gets 4 people in to do this, and they pay a sum of money to that one person, and then those 4 people try to find another 4, so in other words then 16, and eventually you run out of people in order for this sort of system to work, and people on the bottom lose all of their money. And these are outlawed again. There's prohibitions against it, and you can seek some form of remedy on the ACL. Finally, Section 50 of the Australian Consumer Law is to do with harassment and coercion. Now, this is similar to common law duress, but unlike other areas in the ACL, it applies very, very broadly. It will apply not just in trade and commerce, but in any situation where a party supplies goods or services. So harassment and coercion can apply to the private sale of goods. It's something just leave on the back of your mind. It kind of makes sense, though, that threatening people and actually using unfair, scary, nasty standover tactics in order to buy and sell goods is unacceptable behaviour. And the common law remedies for duress only really works in situations where there are actual contracts. And again, it only gives the parties the right to undo, to make void that contract. And in the ACL Section 50, though, the parties do get to use the remedies in the Australian Consumer Law, and the courts can grant a wide variety of remedies, both to compensate the party that is wronged in that situation, but also to be able to smack down, I suppose, the party that is doing the coercion or harassment. Another very important area in the Australian Consumer Law are the implied conditions that are consumer guarantees. Now, really importantly, Section 64 of the Australian Consumer Law says you cannot exclude these consumer guarantees by contract. So unlike the implied terms in the Sale of Goods Act, these consumer guarantees in sections 51 through 58 of the Australian Consumer Law cannot be excluded, and parties purporting to do so, any clause that purports to do so, is void. Now, the key part here is that not only must the supplier be in trade and commerce, but the person purchasing the particular goods or services must be a consumer. And there's a statutory definition of consumer. That is going to be a person, a natural person, as well as a business, if they're purchasing goods that are worth less than $40,000, and the goods themselves aren't for resale or for or to be consumed in the manufacturing process. That's the key distinction here, that you must be a consumer in order for these consumer guarantees to apply. And so they're very similar, most of them, to the Sale of Goods Act rules, that essentially the party selling the goods must have title to those goods. They are guaranteeing that they have title and can pass good title to the consumer purchasing those goods. They also guarantee undisturbed possession. They guarantee that the goods are free from securities or charges upon those goods, so a third party isn't going to come along and say, hey, we're the finance company, we actually own these. They're guaranteeing the goods are of acceptable quality. Now, this is different from the Sale of Goods definition, which was merchantable quality. It's actually a higher standard. And the key part there, and this also relates to the fitness of purpose, it has to be fitness for all reasonable purposes, not just those that are disclosed. So that the standard and quality of goods that are supplied in a consumer contract is of a higher standard, and it has to be fit for all reasonable purposes, as well as any particular purpose disclosed, if there is an unusual set of situation that you're going to be using goods for. Goods must also comply with the description and comply with any sample for a sales by sample. And this includes both sales by sample and when a sample is provided in and around the time of formation. There's also an additional set of rules in Section 58 of the ASGL to do with repairs and spare parts. These things have to be able to be done and catered for reasonably by the seller. And the important part about the Australian consumer law, these remedies apply both to consumers and to businesses that are able to, as the plaintiff, go where there's a breach, for example, of Section, say, 18 or 2021. Now, as well as getting this right to rescind, again, very similar to the common law, the courts have very clear additional remedies that they can go through and do. And they can. The key part here is Section 236 is they can give damages. The plaintiff can actually recover damages as well as being able to rescind or undo the contract. The courts can also vary contracts. They can declare parts of it void. They can refuse particular parts of a contract to be enforced, and they can direct one party to both refund and to also compensate above and beyond the amount required to refund the goods. They can also order the payment of loss of damages for loss that's occurred consequence to the sale of goods or the supply of services. They can direct one party to repair. Now, again, we go back to those rules of specific performance. In equity, you can't usually get the right to force the other party to come and repair your things. You usually just get money. And the courts are pretty much follow those rules as well here. They won't usually, where a party will refuse to actually do it, then and they've made clear that they won't do it, then they will usually enforce the cost of getting a third party to come and fix those particular defects in goods and services supplied. And finally, you can get an injunction. You can actually force a party to not perform a series of things, or to not act or not work in a particular area, and that can actually arise under the Australian consumer law or in any of the areas that we've talked about earlier in this recording. There are, as well as the remedies mentioned earlier, consumers can also seek particular remedies for breaches of the consumer guarantees from sections 51 through to 58 of the Australian consumer law. And basically the type of failure that the particular supplier or the goods have actually happened to gives the innocent party in the situation different sorts of remedies. So a major failure, a substantial defect in the product, gives that innocent party this right to either reject the goods if they're still being sold to them, to return them, get a refund, to terminate the contract, or the court can also grant some form of compensation for reduction of value in that situation. Whereas non-major failures, the seller in those situations can actually offer to repair the goods in that situation, or to remedy the services by coming out and repairing minor defects to work. Now, if they don't do this, they refuse to do this, then the court will have the power to either make them repair or make them refund the goods in entirety. Now, the final component of the CCA that we're talking about here, so this isn't in the Australian Consumer Law, this is in the Competition Consumer Act, the main act, deals with restrictive trade practices. It's really a broad series of rules trying to stop businesses from misusing their market power. And they can do this in a broad variety of ways, all of which are prohibited. Now, this idea of having this antitrust or anti-competitive rules is actually quite old. Parliament has been creating and constructing rules to prohibit this type of behaviour for a long time, but it is, in modern terms, it's been enshrined in the CCA, and so there are rules stopping parties from basically coming together and collaborating and conspiring against the public. So when particular businesses operating in the same industry, for example, petrol stations, come together, if they all conspire together to raise the price of petrol, there's very little that the public can do to this, again, in situations where there isn't sufficient competition. And so as a result, entities, particularly large entities that form some sort of oligopoly, where they essentially are a small number of players that are the suppliers of all of the products in a particular industry, these are prohibited, and Section 45 broadly prohibits that situation. And similarly, where there are one or a small number of groups that can misuse their market power, particularly to lower prices drastically in order to place, to get smaller players to all go broke, and then after all the small players have gone broke, those larger players then can just increase their prices again. They can do that because they can essentially subsidize one arm of their business through still being profitable in a lot of other arms, with a long-term goal in mind. And that's misuse of their market power, and again, that's prohibited under the CCA. Exclusive dealing is a situation where large players can tie businesses into only dealing with them, essentially reducing competition through using their power to force parties to only deal with them. An example you might think of are things like purchasing motor vehicles, where you can only go to authorized Toyota or authorized Honda repair agencies or service agencies who charge an arm and a leg in order to service the vehicle. And again, these things in the broad sense are outlawed and prohibited. However, often these large entities can know how far they can go on these things, and so they will often customize their products sufficiently in order to bypass those rules. Finally, Section 48 deals with large players preventing or placing restrictions on their own dealers, usually separate entities, from protecting them from being able to sell prices and sell particular products at certain prices in certain environments. And again, the large sellers and the large suppliers in these situations have a lot of power over these small on-sellers. And in situations where that power is abused by those large players, the CCA can step in, and the regulator, which is the ACCC, can force those parties to act reasonably in those circumstances. Now, I hope that this recording has been useful as a broad overview of the Sale of Goods Act and the ACL. And again, I reiterate the key distinction between them. The Sale of Goods Act is only to do with goods, and anything in it can be overridden by contract. Essentially, it's a set of default mechanisms for parties selling goods, and it's older. It's over 100 years old. Whereas the Competition and Consumer Act, and Schedule 2 to that, which is the Australian Consumer Law, is a far more recent phenomena. The consumer guarantees that protect consumers are designed, and they can be quite onerous to businesses in some situations. They're really there to protect consumers. But just make note that the remedies that a party can seek, and these consumer guarantees, cannot be overridden through agreement between the parties. They are always available to a consumer in those sorts of contracts.